National and international media are awash with stories of public protests, demonstrations, and processions concerning various and national public issues. Public meetings, processions, protests, and demonstrations have been used over the years by various groups to advocate for change, show support for an issue, or to raise awareness. They have been the primary vehicle through which the rights to the freedoms of assembly, association, and expression have been realized. Enjoyment of these freedoms is key to any democratic society. In Zambia, the Constitution provides for these freedoms in Articles 20 and 21, and the Public Order Act, Chapter 113 of the Laws of Zambia, regulates the holding of public gatherings and procession. The Public Order Act is a 1955 act inherited from the colonial administration. It has been viewed by most stakeholders to hinder the enjoyment of the freedoms of assembly, association, and expression, thereby stifling the democratic space and going against democratic governance principles.
If there was no approval, then what? No. But the law is clear that we are just supposed to give a notice, and then the police can tell us. Yes. It's the notice. Within 7 days, we did notice the police. Then you wait for the approval. No, but it's already more than 7 days. It has passed 7 days. It's illegal. They're not supposed to do this. Okay, so when you look...
In an endeavor to enhance good democratic principles and practices, government committed itself to uphold the rule of law and to amend relevant legislation to achieve this.
I will uphold and maintain the Constitution and the laws of Zambia, and that I will dedicate my abilities to the service and welfare of the people of Zambia.
In keeping with the New Dawn government's promise to uphold the rule of law and democratic governance principles, Cabinet approved the repeal and replacement of the Public Order Act.
Rule of law being integral to that, restoring order, respecting human rights, liberties, and freedoms.
I now officially launch the review of the Public Order Act, Cap 113 of the Laws of Zambia. May God bless our great country as we endeavor to review this particular.
The Law Development Commission was tasked to lead the process to review the Public Order Act and to develop a bill to repeal and replace the Public Order Act. The overall objective of the law review process is to repeal and replace the Public Order Act in order to develop a legal framework that regulates public assemblies and meetings anchored on constitutionally guaranteed fundamental rights and freedoms. In this light, that a call for submissions was sent out to the general public and to key stakeholders, calling on them to make submissions on what should be changed in the Public Order Act and contained in the new legislation. The call was placed on the websites of the Commission, Ministry of Justice, and Ministry of Home Affairs and Internal Security. The advert was also placed in both print and electronic media, which included the national broadcaster and private broadcasters, as well as public and private print media. In addition, the Zambia Law Development Commission sent letters to 432 stakeholders, which included 173 members of parliament and officers of the National Assembly, 10 town clerks in the 10 provincial centers, 52 political parties, 51 civil society organizations, 9 religious organizations, 11 academia, 9 student unions, 14 government ministries and departments, 13 media houses, 42 statutory bodies, 13 trade unions, and 25 professional bodies and associations. The Commission accepted submissions sent in English or any of the 7 major local languages, in handwriting, typed, or in WhatsApp audio format. The Commission received a total of 53 submissions from stakeholders. Some of the key concerns raised by stakeholders in their submissions related to the lack of regulations, the appeal process, exemptions of the Act, lack of prescriptive provisions, and the biased enforcement of the Act.
The PF colleagues come with somewhere across the country, GBM somewhere, everywhere. They are campaigning. This is a campaign time. The election is in a few days.
The review team undertook a desk review of the Public Order Act, related legislation, and the Zambian legal framework, and reviewed, analyzed, and documented international and regional standards and best practices. The desk review also included a further mapping of stakeholders to participate in the process, particularly in the National Stakeholder Consultative Meeting, Roundtable Meeting, and development of the consultative meeting tools. The desk review process culminated into the development of the Zero Draft Bill and the project report. The Zambia Law Development Commission subjected a draft bill at the National Consultative Meeting to 129 stakeholders identified during the stakeholder mapping exercise and stakeholders who made written or oral submissions. These included political parties, civil society organizations, religious organizations, academia, student unions, government ministries and departments, statutory bodies, trade unions, and professional bodies and associations. The draft bill was also subjected to stakeholders at a roundtable meeting with the Law Association of Zambia and Defense and Security Wings to solicit for their input and submissions.
First and foremost, let me welcome you all to this national validation meeting for the review of the Public Order Act, Chapter 113 of the Laws of Zambia.
The findings of the review related to the name of the Act, the notice period, acknowledgement of notices, types of gatherings, restriction of gatherings, a register of notices, an appeals process, the regulatory body, and adherence to the law. It was observed that in Sierra Leone, Kenya, Nigeria, England, and Brunei, the Act is also called the Public Order Act, while in Uganda and South Africa, the Public Management Act and the Regulations of Gatherings Act, respectively. However, in Malawi, public meetings are regulated by the Police Act. The findings revealed that the United Nations 10 Principles for the Proper Management of Assemblies provides that the period for lodging notification of an intended assembly should be ideally within 48 hours. However, stakeholders were of the view that notice to hold a public gathering should be given within 72 hours, while others submitted that a 5-day notice was more practicable. The Public Order Acts of Kenya, Sierra Leone, and Brunei provide for exceptions and exclusions of a particular class of persons or organizations from requirement to obtain a notice or a permit to hold meetings and processions in public places. The findings also revealed that most of the countries in the comparative study provide for different types of public gatherings. These include meetings, processions, demonstrations, and spontaneous gatherings. Further, stakeholders submitted that the proposed law should provide for different types of gatherings, such as multiple concurrent assemblies and spontaneous assemblies. Stakeholders submitted that once a notice of intention to hold a public gathering is given, the organizer should be allowed to proceed to hold the meeting without restriction, and the police should avail themselves to maintain law and order. Finally, it was observed that all the countries in the comparative study provided for a penalty for the offense of an unlawful assembly. In view of the findings, the name of the Act has been proposed to be renamed the Public Gatherings Bill, because this name facilitates the exercise of the freedom of assembly, association, and expression, rather than to restrict it, and is specific as to what the Act seeks to regulate. The law must be reviewed to ensure that provisions on restrictions of gatherings are in line with good tenets of democracy. The law must provide for a register of notices, and the register must be available for persons to inspect at any time during working hours. The proposed law should regulate meetings, demonstrations, and processions, and have a provision on spontaneous gatherings and multiple concurrent gatherings, and place an obligation on the authorized officer to facilitate the holding of such gatherings where practicable. The law under review must provide that any person intending to hold a public meeting must give a notice within a reasonable time to the authorized officer. The law must also provide the form that the notice must take. The proposed law should have provisions to exempt certain classes of people or organizations from notifying the law enforcement agencies for holding of meetings and processions in public places. These exemptions include the President, Vice President, the Speaker or Deputy Speaker, Minister, a provincial minister, a mayor, council chairperson, a member of parliament in their constituency and councillor, funerals and wedding gatherings. Modern law on crowd control requires the proper management of public gatherings and assemblies. The African Charter on Human and People's Rights, to which Zambia is party, promulgates the right to assembly and also provides other rights which enhance the enjoyment of this right. It stipulates that every individual shall have the right to assemble freely with others. However, the exercise of this right shall be subject to necessary restrictions provided for by law. In particular, those enacted in the interest of national security, safety, health, ethics, rights, and freedoms of others. Similarly, the United Nations 10 Principles for the Proper Management of Assemblies provides that every person has the inalienable right to take part in any peaceful assembly, and it is the state's obligation to facilitate and protect these assemblies. This places an obligation on the states to facilitate the enjoyment of these rights by taking measures to protect those exercising their rights from violence or interference. The principles entail that states are obligated under international law to respect and protect without any discrimination the rights of all those who participate in assemblies, as well as monitors and bystanders. It was in this vein that a human rights approach was undertaken in the development of the proposed new legislation, which differs from the spirit of the current Public Order Act, that according to stakeholders stifles the enjoyment of the freedoms of assembly, association and expression as provided for in the Constitution. The name of the Act has changed from Public Order Act to the Public Gatherings Bill, and its central purpose is to facilitate the exercise of the freedom of assembly, association and expression at public gatherings, to regulate the conduct of public gatherings for the preservation of public order and public safety, and to repeal and replace the Public Order Act of 1955. The Public Gatherings Bill 2022 has an enhanced definition of terms that will help readers understand the law, and it provides for the acknowledgement of notice, restriction of public gatherings, multiple notices, duties and obligations of the authorized officer, obligations of organizers, monitoring of public gatherings by media and stakeholders, appeals, prohibition of firearms or weapons at public gatherings, register of notices, regulation as well as prohibition of attires in connection with defense forces and security officers. Oversight on the review of the Public Order Act. The review of the Public Order Act was conducted under the guidance of the Technical Committee that was constituted by the Minister of Home Affairs and Internal Security. The Technical Committee comprised of experts from civil society organizations, academia, and the government ministries and departments. At every milestone in the review process, the review team presented its findings to the Technical Committee, who would make submissions on the practical applicability of the findings and the recommendations made. In addition, as per requirement of the Zambia Law Development Commission Act and processes, the draft review report and the proposed public gathering bill were presented to the Commission for its final approval before submission to the instructing Ministry of Home Affairs and Internal Security. In conclusion, the Commission has compiled its research findings, including all stakeholder submissions and recommendations of the Technical Committee in the project report and draft public gathering bill, which are to be handed over to the Minister of Home Affairs and Internal Security. The Commission would like to thank the Ministry of Home Affairs and Internal Security for entrusting it with the great responsibility of carrying out this law review process, stakeholders who dedicated themselves to the consultative process, and the cooperating partners for facilitating the law review process through financial support. And finally, the Technical Committee who ably guided the law review process. It is the Commission's hope and that of the Technical Committee that the work done will contribute to the enjoyment of the freedoms of assembly, association, and expression as enshrined in the Constitution and other international and regional best practices.